I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are jumping into number 163 on our compilation list. We will be in 3 different courtrooms on today. But before I give you the rundown of those courtrooms, don't forget to like, comment, share, and subscribe. It is much appreciated. Also, I just want to say thank you guys for all of your comments in the comment section. All of the ones that I'm able to read, I try to respond to in some way, shape, or form. So thank you guys for putting your comments down in the comment section, giving your opinion, giving your thoughts, jokes, all of the different things that you guys add to this channel in the comment section is much appreciated. Don't forget that commentary will be left in some of these proceedings that is added into this compilation. Also, chapters will be added for your convenience. Now, the 3 courtrooms we will be in on today. First, we will be in the courtroom of the legendary Judge Jeffrey Middleton out of the state of Michigan. Second, we will be in San Diego Superior Court for a special appearance. And let's see if any of you guys recognize who this particular sovereign citizen is in this second proceeding in our San Diego Superior Court. And some of you may have already seen it because we shared it on this channel. But if you have not, I'm sure it's going to be a surprise to many of you. And last but not least, we will be in the courtroom of Judge Sheila Brown, also out of the state of Michigan. It's about that time, guys. Let's go ahead and jump into 163.
Mr. Hicks, why don't you come on up and talk to you, or Mr. Aiken? That wasn't his.
You're on special appearance and fine.
All right, well, we'll talk about that here. This is file number, what's that?
You're on special appearance in the divine and living.
Okay, could you hand that to me? Well, first let me call the case. This is file number 222036SM. Give this back to you. You don't want to lose this. This is a birth certificate for Justin Michael Aiken. And he happens to be the person that got this citation, Justin Michael Aiken. I don't want to keep that. I don't want you to lose it. You need it. Anyway, that's you. Mr. Aiken, you're here under one appearance or another. You got a citation charging with having no insurance. The last lady had the same charge. That's a misdemeanor. It's punishable by up to a year in jail, a fine of up to $500 and not less than $200. The second count is the one that carries a driving suspension. That's called driving suspended. That's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. That carries 2 points and it requires that your license be suspended. So that could affect your ability to drive a car. And then the third count is a registration plate violation, which is a civil infraction. I don't know if there's any sort of plea offer at this point. There probably isn't. What was your advice, Ms. Jackson?
I advised him that he should plead not guilty, ask for a pretrial, and pay off what is suspending him, which is basically a couple of tickets of relief out of Greenwich County. See if he can't get some reduction on that charge.
That's not bad advice. Mr. Aiken, she's recommending at this point that you plead not guilty, and I don't have a problem with that. Your driving record shows that you had some previous insurance tickets that you didn't pay. And then she indicates you may also have some things from Indiana, LaGrange County.
Branch me.
What's that?
Branch County.
Branch County. Okay, let me look at this because I did look at this yesterday. The staff has been talking with you. They say you're very polite and respectful, but may not completely understand everything. Your driving record shows that you are currently suspended. You do have an ID. You have Coldwater, March of 22, fail to comply with judgment, that means you didn't pay the ticket. And so her advice is probably pretty good. What would you like to do, sir?
Well, there's case laws here that states that the use of an automobile as necessary against the earnings of a livelihood as modern life requires use in the interest of realism to conclude the right to use as an automobile on the public highways partakes of nature of a liberty within the meaning of the constitutional guarantees. Barbarian versus Luzier, 1958, 139, A2D, 869, and then the right to operate a automobile upon the public streets and highways is not a mere privilege. It is a right of a liberty, the enjoyment of which is protected by the guarantees of the federal and state constitutions. Adam versus City of the Pocatello, 416 P.2D 46 4891 Idaho 99 1966, and a traveler has the right to employ an automobile as a means of transportation and to occupy the public's highways with other vehicles in common use. Campbell versus Walker, 78, Atlanta 601 603 2 Boyce Dell 41. Also, the word automobile connotes a pleasure vehicle designed for the transportation of persons on highways. American Mutual Liability Insurance Co. versus Chaput 60A.2 D2, 118. Motor vehicle, the term motor vehicle means every description of the carriage or otherwise convenience propelled or drawn by mechanical power and used for commercial purposes on the highways. The term used for commercial purposes means the carriage or a person or property for any fare, fee, rate, charge, or other considerations or directly or indirectly in connection with any business or other undertakings intended for profit. A motor vehicle or automobile for hire is a motor vehicle other than an automobile stage used for the transportation of persons for which remuneration is received. International Motor Transit Co. versus Seattle 251 P120.
So does that mean you want to plead not guilty to this stuff?
Yes.
All right.
Because
I don't know if there's a club, you pay dues. As I said, the staff said you've been very polite and respectful, but you are woefully misinformed. People keep coming up with these.
I have one more thing to say.
Well, anyway, everything you just said has no meaning to whether or not you need a valid driver's license or insurance in the state of Michigan. And the problem is, Mr. Aiken, you could take all this misinformation and really get yourself in a difficult circumstance. I don't know who's teaching you this, whether you learned it yourself off the internet or you've got a mentor that is taking you down this rabbit hole. But I don't want you to get yourself in a situation where you're going to have to live to be 99 years old to get your driver's license back. So first of all, Mr. Jackson's advice that you pay the ticket in Branch County would be helpful. Everything you just said has a thimbles full, an empty thimbles full worth of effect on anything. Your driver's license is suspended by the state of Michigan. You can travel all you want, but you can't drive a car until you get that cleared up. Secondly, you're not an independent nation unto yourself. You need insurance. I don't want you to get all sideways where you can't get your license back from following this irrelevant, meaningless information that you've been provided with. You seem like a nice young man. So I'm going to show you a plead not guilty. Would you give Mr. Aiken his birth certificate back? I don't want him to lose that. Now, you said there was something else you wanted to tell me?
Yes, if that's okay, Your Honor.
Yeah.
Okay, it states right here, under U.S. Supreme Court decision, that common law is the real law, the supreme law of the land, that codes, rules, regulations, policy, and statutes are not the law. So therefore, as in insurance, regulations, title, tags are not law. That's as it's stated here, Rodriguez versus Ray Donovan, U.S. Department of Labor, 1769, or 769 F 2D 1344, 1348, 1985. And then U.S. Supreme Court decision 1796, There every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Courtroom versus Neal. And this decision has never been overturned.
Okay, I'm not sure where you get this stuff. If that were true, you wouldn't need me, you wouldn't need police, you'd have anarchy and people rioting in the streets and doing, we're about there now. People do whatever they feel like. If somebody says something they don't like, they shoot them. Somebody says something they don't like, they punch them in the nose. They feel like everybody else's property is their property. There's something here in the United States, here in Michigan and here in St. Joe County called the rule of law. And the judges don't make the laws, the legislature does. The judges are sworn to enforce them. So at this point, somebody gave you all this information, which doesn't really affect anything, and it isn't a legitimate defense. You're entitled to have it. You're entitled to be misinformed. I can't, and you're entitled to believe what you want. You're entitled to have a trial in front of 6 jurors.
We can do that.
This isn't even, that stuff won't even get to a jury. The only question would be, did you have insurance and were you driving? Anyway, as I said, I don't want you to get on the driving suspended merry-go-round and you'd be unable to get off of it. Whoever is giving you this information is doing you a terrible disservice. You got these tickets in other jurisdictions that you didn't pay. Now you're suspended. How'd you get here today?
I got a ride. Somebody gave me a ride.
All right. Well, don't drive anymore until we sort this out. Stop driving. I would like to see you get back on the right side of having a driver's license. This stuff is not helpful. It doesn't aid your cause. It has little meaning. And the bottom line is you need to have a valid driver's license. You need to have insurance. This stuff doesn't carry any love or weight in any court in the state of Michigan. So I'm going to show you're pleading not guilty. We'll send you out to the court office. We'll have a pretrial. You can share your thoughts and beliefs with the prosecutor. It'll probably just make them mad. But Miss Jackson's advice is a good one. If you can go get the tickets paid off, get your license available to get it, they may give you some consideration. But you live in Constantine, which is a little place.
Right.
Every time you drive, they're going to pull you over again.
Yeah,
We're going to be on the merry-go-round and we won't be able to get off of it. So, like I said, you've always been polite and respectful and you're entitled to believe what you want, but this isn't helpful to your cause. So we'll get a pretrial, let you share that information with the prosecutor, see what they want to do. But Ms. Jackson's advice, I think, is good advice.
Okay.
All right, Mr. Aiken, why don't you take him out to the counter? Now, what's going to happen next, and I apologize, once upon a time we used to do the pretrial right here at the time of the arraignment, but with county cases, we're not able to do that presently. Are you missing work right now?
No, not right now.
Okay, good. I don't want you to have to take time off from work to come back here, but we'll talk further about this. And if you want a trial, you're ultimately entitled to have one. My hope is you could get some of this stuff squared away and the prosecutor will give you some consideration, help you get your valid license back. But when you were young, you took driver's ed, you did all the steps you needed to do to get a valid license?
Correct. I did then. That was before I actually started researching into law, actual common law of the United States of America, which is common law, God's law. Legal is undoing of God's law, illegally. That's what it comes down to. I mean, I know you don't know it. It's just there's a whole bunch of fraud.
Well, I didn't just fall off the turnip truck. I've been here for 42 years, and people have been making these harebrained arguments for years, and they don't carry any weight. And I'm sorry that you have gone down this path, but it isn't going to be beneficial. And the better, and you went to all the effort to get a driver's license. Don't throw it away because of some mistaken beliefs about something that was rendered in 1796. So anyway, we'll send you out for a pretrial and we'll see where this goes. But I appreciate the fact that you are polite, respectful, and you have a right to believe misinformation if you want to, but it isn't in your best interest. All right, good luck, sir. We'll probably talk further.
Mr. McCurry, did you have any objections, sir, to the media request? You indicated that you did, that you had an objection, and the court indicated that its tentative was to grant the request for media coverage. Did you wish to put that on the record or no?
Yes, I mean, I'd like to put it on the record, only because I have other children than my 18-year-old son, which this matter is involving.
Okay, but only as it relates to the media request.
Oh, I just wanted to make sure that my other children weren't in the media if I mention their names or if it comes up in if it comes up in the proceedings.
Okay, thank you. And so the court finds good cause to grant the media coverage. The media coverage was granted as relates to ABC 10 News, and the court authorizes the sharing of media news feeds with other media outlets. So that is authorized. Upon further review of this case, the court finds that Mr. McCurry was before the court on October 7th, 2025. At that point, his request for self-representation was granted. However, the court finds that his acknowledgement of advice of rights regarding extradition was not signed. Sir, prior to representing yourself, were you advised of your rights regarding extradition?
All I know is that I was supposed to be on a 72-hour hold, and
Sir, my question to you is, were you advised of your rights regarding extradition?
no, Your Honor, I was not.
The court advises you as follows. The defendant in this matter has been advised of the following rights. The right to require the issuance and service of a warrant of extradition by the governor of the state of California before he can return to the state demanding his extradition. The right to have a qualified lawyer represent him in the proceedings in this state at all stages of the proceedings, and that said attorney may be the defendant's own choosing or shall be court appointed if the defendant is unable to afford counsel. When a warrant is issued by the governor of the state of California and served on the defendant has the right to test the legality of such warrant by a writ of habeas corpus and has the right to a reasonable time after the service of said warrant in which to apply for the writ of habeas corpus. The court finds that the defendant has been advised of his rights regarding extradition on the record in open court on October 15th, 2025. As relates to the complaint, sir, are you prepared to go forward with your arraignment?
Yes, Your Honor.
Please do so.
I wanted to call attention to the emergency motion that I filed. Based on the fact that the 50th District has completely continued to violate all of my rights, my 4th, my 5th, my 14th Amendment, my right to due process is constantly trampled. And I've figured out why, because under due process clause of the 14th Amendment, personal judgment is void if rendered by the court, which has no jurisdiction over the defendant. That's Penmore versus Neff, 95 U.S. 714, 24L, ED 565. And Michigan has no jurisdiction. Before we proceed, we need to establish jurisdiction. It's imperative that we establish jurisdiction.
People?
Your Honor, the people would argue that this motion is not relevant to the proceedings before the court, that it is now time to either admit guilt or not guilt as to the fugitive complaint that the people have filed.
Okay, thank you. Sir, did you care to respond before the court rules on your motion?
There's no injured party, Your Honor. Oh, I'd like to also say I'm here in special appearance.
Specially appearing for who?
I'm here on special appearance.
Sir, who are you specially appearing for?
I'm specially appearing for Darius McCurry. I'm here pro per special appearance.
And when you say you were here pro per and special appearance, who are you?
I'm an authorized signatory thereof of the estate and the executor of the estate.
Who's the state?
The McCurry estate.
And your name is?
I'm Darius. I'm the authorized signatory thereof, Darius McCurry.
And your name is?
Darius McCurry.
Okay, thank you. Anything else as it relates to your motion?
I would also like to add that there's been as far as corpus delicti is concerned, I wanted to know who's the injured party.
The court finds that the issue before this court is the issue of extradition. This court is not the demanding state where many of these issues raised by the defendant may be relevant. This court is tasked with ensuring that the defendant is returned to the demanding state. That will happen either one or two ways. He will waive extradition or he will plead not guilty to the complaint regarding extradition, at which time a governor's warrant will be provided to the court at a later date. Those are the things that this court is tasked with deciding at this point in time. If you have any issues regarding the charges pending against you in the demanding state, then you may raise those in the demanding state. The thing before the court today is the extradition and the extradition only. As it relates to the extradition, is there anything else?
Well, Your Honor, is it possible that we could discuss a bail?
Bail arguments are heard after the entering of a plea has taken place. Again, as it relates to the extradition, are you prepared to proceed?
Yes, Your Honor.
Please do.
Meaning?
You're here for an arraignment. You were granted the right to represent yourself. When you made that request, you indicated that you would have the ability, the knowledge, the education to represent yourself in these proceedings. That request was granted. You were advised that you would not receive any special treatment as a pro se litigant, that you would be treated the same as an attorney. You are here for an arraignment on the complaint. Please arraign yourself.
Well, I'm asking, can we discuss bail, Your Honor?
And I have told you that the discussion of bail arguments are conducted after the entering of the plea.
Okay, Your Honor. So I guess I'm playing. What is it? No. I really.
Do you understand the legal proceedings pending before you?
I do, Your Honor. I do, but
So then please proceed with the arraignment.
So I wasn't here. I wasn't aware that we were here to contract today.
Okay, thank you. The court has attempted to conduct the arraignment with Mr. McCrary, and it is evident to the court that he is unable to understand and appreciate the legalities of these proceedings. As such, the court finds good cause to revoke his pro per status. The court appoints the office of the primary public defender's office to represent him. This matter is trailed.
Thank you.
All right, thank you.
Thank you.
Your Honor, calling number 105, Turner versus custody taken. Custody take.
Good morning, Your Honor. Vanessa Duval, Deputy District Attorney for the People.
Julie Gibson, Office of the Public Defender, on behalf of Mr. Darius McCray, who is present in custody. Your Honor, we are here for arraignment on the complaint. He's been advised of his constitutional rights, previously signed the acknowledgement. We are entering pleas of not guilty, denial to any and all allegations, asking for appointment of the primary public defender's office, and would like to be heard with regard to his custodial status.
Okay, thank you. Thank you, and just for the record, the defendant did not sign the advisor of rights regarding extradition. Previously, the court went over those advisors with him in open court today on the record.
Thank you.
The court appoints the office of the primary public defender's office to represent him. Mr. McCrary's true name and date of birth appear on the fugitive complaint. He was advised of his rights regarding extradition. He waives further reading of the charges. The court enters his not guilty pleas to the charges and his denial of the allegations. The court has appointed primary public defender's office to represent him. As relates to dates, the court will set this matter in 30 days for the governor's warrant, and that date is?
That date would be November 14, 2025 at 8:30, Department 101.
All right, thank you. As it relates to bail, the either counsel wish to be heard.
Yes, Your Honor.
Yes, Your Honor.
Please proceed, Ms. Gibson.
My argument has, I would ask that Ms. Ball be heard first. My understanding is she's going to make argument, and I don't have all the facts as to why it should be no bail, and I would ask for her to make those arguments first.
Okay, thank you. Ms. Duvall?
Yes, Your Honor. The fugitive is before the court today for absconding or forfeiting bond on a non-payment of child support case out of Michigan. Clearly, Mr. McCrary is not attending to his family matters. He has 2 daughters and 1 son, and this matter is regarding 1 daughter who lives in Michigan. He has previously been ordered to pay child support. As of August 20th of last year, he owed $75,473.26. He owes substantially more at this time. However, Michigan could not give me a figure due to privacy reasons. The defendant has been arrested twice in the past on these same charges, in 2015 and 2023. In 2004, he's been arrested for disturbing the peace. Back in 2023, the fugitive had to be extradited from Los Angeles for these very same charges. The defendant was arrested coming back from Mexico. According to his agent, he was looking at buying real estate down there. He lists his current address as Woodland Hills, which is not in the county of San Diego, but in the county of Los Angeles. He has no ties to San Diego or Michigan. When he left Michigan, he actually had what they describe as a TIGA, which is electronic monitoring, when he left the state of Michigan. For all those reasons, the people would argue that he is a flight risk. He's failed to take care of his obligations back in Michigan. We'd be asking for no bail in this matter.
Thank you. Ms. Gibson?
Your Honor, we are asking the court to set bail in the amount of $50,000, an amount for which he can afford. He made multiple court appearances on this case. There was the last time that apparently there was a notifying letter that was sent. They sent it, the district attorney's office in that state had both his email address, his phone number, as well as his counsel's email address, and they chose to send a notifying letter to a P.O. box that was not monitored by him often. And so with regard to the issue of coming across the border, he was across the border working with a group to build homes in Tijuana. There was nothing nefarious about what he was doing. We're asking the court, again, since there are no failures to appear that he has other than that demanding state, we're asking the court to set bail in the amount of $50,000, an amount for which he can afford, and he will make his court appearances. I've already talked to people that are here on his behalf that are part of his team and represent that he will be returning to the demanding state. He is ill right now, and so I apologize to the court that it's taken a while to have the conversation, but he is adamant. He is a renowned figure. Everyone knows, that's why there are media here on his behalf, that he's going to appear in court. And I understand what the district attorney is saying with regard to prior incidents, but if they wanted him to appear in court, they had multiple ways to get him, and he did not know of the appearance date. So we're asking the court not to release him on OR, but to set bail in a reasonable amount that is $50,000 for him to make his court appearances.
Okay, thank you. Both counsel submit?
Yes, Your Honor.
Yes, Your Honor.
Thank you. The court has considered the arguments of both counsel here today, and the court finds as follows. The court finds that the defendant has previously been extradited, that he was arrested coming back from another country. It has been represented to the court that he has no ties with the demanding state, and most notably that he was on bond previously and absconded. Based upon those factors and findings, the court finds that the defendant is a flight risk, denies his request to set bail. He'll continue to be held without bail.
Your Honor,
And that will be the order of the court.
I apologize. Thank you, Your Honor. At this time, after having previous discussions with Mr. McCrary, he is prepared to admit identity, I think he has, and to waive extradition.
He has not admitted identity.
Your Honor, he does admit identity, and he is asking the court to allow him to sign the extradition paperwork, and so we're getting some now. I did not have them. I'm not sure where they are from before, but that is our request to the court.
Okay, thank you. Sir, are you Mr. Darius McCrary?
Yeah, I'm Darius McCurry, yeah.
Okay, thank you. The court confirms the identity of Mr. McCrary as he's identified himself as Darius McCrary.
Yes.
Can we also get an audit?
Hold on.
You sure?
Your Honor, I apologize. It's going to take me a moment to complete these. How would the court like to proceed? Does the court mind waiting while I fill out these forms? They're blank.
Court's in a brief recess.
Thank you, Your Honor. Sir, I don't know what an audit is.
Ms. Gibson, you prepared to proceed?
Yes, Your Honor.
Okay, thank you. We're back on the record. The court is in receipt of the signed acknowledgement of advisement of rights regarding extradition signed by the defendant. The court is in receipt of a signed waiver of extradition to the state of Michigan signed by the defendant, and the court finds a valid waiver of extradition to the state of Michigan, signs the waiver of extradition. As such, this defendant is remanded to the custody of the sheriff without bail, and the court sets a 30-day date review hearing in this date, and that date is
November 14, 2025 at 8:30, Department 101.
okay. Thank you. People, given that the defendant has waived extradition, what is your request as it relates to the fugitive complaint?
People move to dismiss it, Your Honor.
That matter is, that request is granted. That matter is dismissed. Thank you both.
Thank you,
Your
Your
Honor,
Honor.
if the court do a medical referral, he is quite sick.
The court grants the request and authorizes a medical referral for the defendant. That concludes this matter. Thank you both.
Thank you, Your
You're
Honor.
welcome. Thank you, Your Honor.
Thank you.
Your Honor, that concludes the morning's calendar.
Thank you. Court is in recess.
Case number 25-00791 State of Michigan versus Timothy Dansby.
Behalf of the people.
7446, standing in for the attorney of record, Van Gonick, and appearing on behalf of Mr. Timothy Dansby, who speaks to my right. Mr. Dansby, can you please state your full name for the record?
All right, Mr. Dansby, we're back. Do you mind having Ms. Miller stand in for Mr. Gonick for today's hearing?
That's up to the court, Your Honor. I still reserve my right. I mentioned all of the previous hearings, but part of today's process has been going what it's going to continue doing what it's doing, but I still.
Does that mean you don't mind her standing in?
Want to interpret?
Okay, you know what? I'm not gonna play that game. It's a yes or no question.
I don't even.
Okay, do you want to adjourn it and see who it is? You have a right to have the counsel of record present if you want to be here instead of Miss Miller. And this is basically for a probable cause conference and adjourn date on a retail fraud first degree. When we had adjourned it before for your lawyers to get video discovery. So do you mind her standing in or no? Okay, so you don't want a lawyer, sir? I'll release him if you don't want one. Nobody's gonna force you to have a lawyer to help you. If you want to do it all yourself, do it. Do you want me to release the lawyers?
You know, same firm soon right now.
Do you want a lawyer? Yes or no? It's a real easy question, sir. It don't take all day. Listen here. Okay, if you don't answer the question, I'm going to release the lawyers. If that's what, because you've been complaining the whole time about, I didn't ask for no state attorney. I don't want to, I don't know what it, whatever you going to do. No, I'm not doing anything. I didn't appoint the person in the first place. I didn't do it. Okay, so you don't want them? Is that what you're telling me? Do you want them? Yes or no?
All on the same.
Sir, listen, this is not going to be a matter of semantics. Do you want one or not? Because nobody's going to force a lawyer on you. I'll be happy to handle this case with you by yourself, doing whatever you can do to help yourself. If that's what you want.
I still ain't got my discovery, so.
So, do you want a lawyer?
I'm sorry, I'm standing on the same thing I stand.
I don't even know what that is. Whatever your claim is, I don't know. Okay, let's release the lawyers. All right. Now, you're not getting another one. I'm just telling you.
I reserve the right for judiciary and judiciary finding on the legitimacy of the court.
You're not getting another lawyer, okay?
Boy, I said
I don't know what you can reserve what you want. I don't mind.
finding the other court and the legitimacy of the court as far as the
Sir, whatever you want to do, you can do. But since you don't want a lawyer, I can't by law give you one. So.
That was three Germans ago.
Guess what? So.
Lord, have you given me the things that I need?
Okay, sir, nobody can give you anything but a piece of paper. They can give you that. They could give you the police report. They cannot give you the videos because there's no way for you to watch them.
Make sure that the law library at the court, give an order that the law library at the court either have a clerk or somebody to present the information for me to see the video. I don't know. Maybe you just don't want to get done.
Sir, I don't even know. I don't know anything about your law library wherever. All I know is these video files. They're files. They come on a computer.
So the law library should somebody should be giving people at the law library a heads up to make it law.
Well, you know what? That's up to you to figure out how you gonna get them.
I'll let the second circuit figure it out. Second circuit figure it out. Probably judge, second court, Supreme Court, we let them figure it out. I'm straight. Well, I ain't doing nothing.
Ready for me to take them?
Your Honor, would you like Mr. Donovan to file any sort of motion or
No,
order to have him withdraw?
no, I'm gonna write an order out right now, releasing him. And so we will reset this, I guess. I don't know why we got him. We could actually bring him back out. He could decide what he wants to do today.
I do know that, he is wanting to have his preliminary examination. That is.
Okay, well, let's set it for an exam then. How many witnesses, Mrs. Shockley?
Probably just me one.
All right. You want to wait for your order? You can.
Okay, thank you. One witness.
Right.
Yeah. One witness and one defendant that's going to make it way longer than it's supposed to be. So factor that in.
Court's available October 3rd at 10:30.
All right. So October 3rd at 10:30. Is the exam date. And could you ask Mr. Gonick to make sure he gets a discovery, what he has, over to this person?
I believe that paper discovery has already been given to him. I'll see if the court or if the jail will allow us to give any sort of drive or anything like that that encloses the videos.
This record, I would advise the court the discovery, the AV discovery in this matter is 99% police body worn camera, which has the defendant in it, and there's only one in-store video of the defendant walking past it. So.
Okay.
You didn't know what.
Okay. Well, good. Just make sure he sees it. Just some of your best efforts on that. And here's the order. In the terms of she was still with her. What did I look at that? Yeah, I did. Let me see.
Thank you, Your Honor. Have a nice day.
Thank you. You too.
Mr. Harris, would you please come to the podium?
I challenge jurisdiction.
Mr. Harris, I need you to step to the podium.
If I step to the podium, it'll be under threat, duress, coercion.
Well, fine, just do it.
Okay, no problem. But I'm here, I'm at the podium under threat, duress, and coercion. Well, other than that, I challenge jurisdiction.
Okay.
Without prejudice, I, Mikael Eric Colin Harris, beneficiary and sovereign principal, am here under fraud, threat, duress, coercion, and extortion fiduciary, Ms. Sheila Johnson. This is a Social Security Cessate Trust action in which you are now a real party and interest to. This is a military admiralty tribunal and maritime law. So you accept the challenge of the jurisdiction.
You can challenge it. I'm not stopping you from challenging it.
Do you accept the challenge?
I don't know what you mean by accept the challenge.
Do you accept that this is a maritime admiralty law?
No.
You don't accept that?
This has nothing to do with admiralty, sir. This is simply a charge that you're here for.
Yeah, but
it's nothing to do with the sea, vessels, or anything like that, which are boats. Admiralty law applies to that.
Yes.
This right here is a driving a car offense. And it's a 93-day misdemeanor carrying up to $500 fine, and it carries a possible suspension of your driver's license, additional points to your driver's license, and possible vehicle immobilization of any vehicle that you're driving. That's what this charge is, and it's not admiralty law. You're using language that legally doesn't make sense for what we're here for.
But all this is a corporation.
Okay.
This is not a are you saying this is not a corporation?
Sir.
I'm asking.
I have no idea what you're even talking about.
But I'm asking you a question. I mean, it is not maritime admiralty law, and also
It's not maritime law.
Is it?
No.
Now that Judge Johnson has that out of the way, she says, listen, Mr. Harris, it's time to run down these charges.
I'm telling you what I know doesn't apply.
Right. I never said that though.
Okay.
What I said is I am a sovereign principal, and I am the beneficiary.
Well, sir.
You are the fiduciary.
I'm telling you that what you are, as whoever you are, is charged with today. Now, you have certain options here. You can certainly have a trial if you want a trial on whether or not you were operating a motor vehicle without a valid license from the state of Michigan because they were suspended.
I object. I've equipped you with all the information you need to show down the sovereign principle, and also to show you in your constitution, it says that I can travel.
Sir, if you want to file a motion, file a motion.
Okay,
because no one can respond to all of this. Whatever you're saying, he can't respond to it.
I motion that you.
You have to file it in writing and cite your authority under law.
I did that.
And if you want to do that, you can do that. Otherwise, we're going to have to set your case for trial.
Under a Power of Appointment Act of 1951, I appoint the judge, executive. I would like y'all not to breach a contract. I mean, breach of duty, breach of fiduciary duties.
Give me a jury trial date.
May 9th.
May 9th. 8:30. If you need to file a motion between now and May 9th, you better do it before the end of March.
Have a great day.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.